Well, friends, there she goes again. Trump-appointed Judge Aileen Cannon just granted Donald Trump's request for yet another unnecessary evidentiary hearing. You know, I would say Judge Cannon has slowed Donald Trump's Florida prosecution, his Florida case, slowed it to a crawl. But let's face it, with her refusal to even set a trial date in the case, she's brought it to a dead stop. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, coincidentally, I just authored a new piece for MSNBC. It was published today. Here's the title: The Unmistakable Evidence That Judge Cannon is Unfit for Trump's Classified Documents Case. And given today's legal development, what Judge Cannon just did, she kind of proved my point. So what I want to do today, friends, is read the piece to you and then turn to today's legal development that continues to prove that Judge Cannon's disqualification cup runneth over. Speaking of cups, it'll take me a few minutes to read the piece. It's a couple of pages long, so if you want to hit pause and grab a beverage, I've got mine here in my Justice Matters mug. On the other side, it says, justice is a team sport. And yes, we all need to be in the game. So, again, here is the title of my new piece for MSNBC, The Unmistakable Evidence That Judge Cannon is Unfit for Trump's Classified Documents Case. Each new development in Donald Trump's federal criminal case in Florida makes it increasingly clear that the impartiality of presiding Judge Aileen Cannon might, as the federal law puts it, reasonably be questioned. That's important because the same statute, 28 U.S. Code Section 455, provides that when a judge's impartiality might reasonably be questioned, the judge shall disqualify herself from the case. It's time for a fair, impartial, and independent judge to assume responsibility for the case. There is a virtual mountain of evidence in the Florida case in favor of Cannon's removal. Even before the case commenced, when Trump complained in a court about the FBI seizing his stuff, Cannon ordered the Justice Department to stop investigating the classified documents that were retrieved from Trump, despite them being seized under a lawfully issued search warrant. She then appointed a special master to review the evidence the FBI had taken, bringing the investigation to a grinding halt. The 11th Circuit Court of Appeals reversed Cannon, finding that she had abused her judicial discretion and emphasizing that no judge has the authority to interfere in an ongoing DOJ investigation. In layman's terms, Cannon did something that the law did not authorize, and she did it to Donald Trump's extreme advantage. And that was even before the actual prosecution came into existence. In June 2023, Trump was indicted in the Florida case. The New York Times reports that after the case was assigned to Cannon, two more experienced colleagues on the federal bench in Florida urged her to pass it up and hand it off to another jurist. Cannon refused. Yet, ever since, we've seen a steady stream of conduct that supports the conclusion that she is either incompetent, in the tank for Trump, or both. Let's start with Cannon's refusal to set a trial date, even though the case has already been kicking around in court for a year. I can't overstate how unusual it is for a federal court judge to decline to set a trial date, particularly after defendant Trump's lawyers informed the judge that they could be prepared to go to trial on August 12th, 2024. Judges set trial dates. It's kind of what they do. It's important to have a date certain for trial because all intermediate deadlines in a criminal case are driven by that timeline. Once a trial date is set, judges will set deadlines for motions to be filed, litigated, and resolved in advance of and dependent upon the trial date. Simply stated, no trial date, no intermediate deadlines need to be set. But because there's no trial date, Cannon has deigned to set seemingly endless evidentiary hearings on motion after motion, mostly from Trump's team. Adding insult to legal injury, Cannon is holding lengthy hearings on motions that most outside observers consider frivolous. A quick word about legal motions in criminal cases. When a defendant files a motion, the defendant must articulate sufficient facts and applicable precedent that, if proven, would actually entitle the defendant to some form of relief or remedy. When a defendant fails to meet this burden of production, judges will almost always resolve the motion with a single word, denied. But Cannon seems to ignore the burden of production requirement, instead setting time-consuming evidentiary hearings. For example, earlier this month, Trump filed a spoliation of evidence challenge, arguing that because the FBI didn't document the exact location of each item inside each box that was seized from Mar-a-Lago, that somehow equates to the FBI intentionally destroying exculpatory evidence. Having reviewed seized evidence in hundreds of criminal cases over my 30 years as a federal prosecutor, this assertion is absurd. When the FBI executes a search warrant, evidence technicians thoroughly document the evidence as it appeared on the scene before it was seized. If the evidence is contained in a box, they'll open the box and photograph the contents as it appeared when they first viewed it. Then, they'll bring the box to an FBI facility, remove each item from the box, and meticulously document each item with photographs, written descriptions, etc. Recently published photographs of the evidence seized at Mar-a-Lago show that the boxes contained a mangled mess of classified documents, golf shirts, newspaper clippings, U.S. military plans, etc. Trump's claim that it was important to know if a particular classified document was nestled against a balled-up golf shirt or a magazine cover depicting Trump, in other words, that the exact placement in the box is somehow of factual and legal significance, is entirely frivolous. Yet, Cannon has refused to dismiss the motion or even to comment one way or another on holding a hearing. Then there is Cannon's risible handling of jury instructions. Trump has argued that the Presidential Records Act, the PRA, authorized him to take top-secret classified documents and national defense information to his Florida resort when he left the presidency. But in substance, the PRA's text supports the opposite proposition. Classified documents remain the property of the federal government after a president leaves office. In some limited circumstances, presidential diaries, personal notes, and other similar documents can be designated as personal rather than presidential records, such that a president can take his diary with him when he leaves the presidency. Classified documents, however, must be delivered to the National Archives for preservation. Against that backdrop, in March, Cannon asked both parties to propose jury instructions that accounted for two competing scenarios. Problem is, both scenarios inaccurately applied the PRA to the case, ignoring the law's purpose and intent. Nevertheless, Cannon instructed the parties that they must assume her instructions were correct formulations of the law. To be clear, judges will occasionally propose a jury instruction and ask the parties, the prosecutors and the defense attorneys, how they view that instruction, whether they believe it's an accurate formulation of the law, and whether they would propose any alternative instructions to the one being offered by the judge. But I've never seen a judge offer what is obviously an incorrect assertion of law and direct the attorneys to assume it's correct. Earlier this month, retired federal judge Shira Scheindlin, who served for 27 years as a judge in the Southern District of New York, expressed her concerns that Cannon was showing, quote, favoritism toward Trump and antagonism toward the prosecutors in the case. Judge Scheindlin also said that, in her experience and estimation, it's apparent that Cannon is either unwilling or unable to discern what motions can be resolved on the papers with a simple denied and which motions actually require an evidentiary hearing. Quote, I think she's inexperienced, and I think it makes her insecure in her rulings, Scheindlin concluded, but the motivation may be mixed in with intentionally delaying enough to make sure this doesn't go before the election. When such concerns and criticisms of a judge's suitability to preside over a given case are voiced by current and former federal judges, it's hard to see how Cannon's impartiality isn't open to being reasonably questioned. It's long past time for her to hand off this crucial case. Okay, friends, thank you for indulging me that. Now, let's turn to the new legal development and today's episode of Cannon's Shenanigans. Let's turn to today's legal development because today, Judge Cannon helped prove and reinforce my point. Here's the new reporting from the New York Times. Headline, Judge to revisit key legal finding in Trump classified documents case. And that article begins, the federal judge overseeing former President Donald Trump's classified documents case said on Thursday that she intended to look anew at a hugely consequential legal victory that prosecutors won last year and that served as a cornerstone of the obstruction charges filed against Trump. In her ruling, the judge, Aileen Cannon, said she would hold a hearing to reconsider another judge's decision to allow prosecutors to pierce the attorney-client privilege of one of Mr. Trump's lawyers under what is known as the crime-fraud exception. That provision allows the government, the prosecutors, to get around the normal protections afforded to a lawyer's communications with a client if the prosecutors can prove that legal advice was used to commit a crime. And prosecutors did prove it to the satisfaction of D.C. Federal District Court Chief Judge Beryl Howell, an extremely experienced and highly regarded jurist in the District of Columbia. She held a hearing, and she ruled that Donald Trump used his lawyer in furtherance of committing a crime so he couldn't use the attorney-client privilege to shield incriminating information that the attorney could provide against Donald Trump. Prosecutors did prove it, and an outstanding judge ruled that the attorney-client privilege yields and that information could be used against Donald Trump. All of that is my editorial addition, and now the article continues. Depending on how Judge Cannon ultimately rules, her decision to redo the fraught and lengthy legal arguments about the crime fraud exception could deal a serious blow to the obstruction charges in the indictment of Mr. Trump. Even if she ends up confirming the initial judge's findings, holding yet another hearing on the issue will take more time and play into Trump's strategy of delaying the case from going to trial for as long as possible. Let's be clear here, friends. This is kind of like Judge Cannon wanting to replay the Super Bowl because she doesn't like the previous results. You know, buried in the middle of her 11-page ruling, we see a glimpse of what's really driving her decisions. In the case of the United States of America versus Donald Trump, Waltine Nauta, and Carlos de Oliveira, defendants, buried in the middle of the 11-page ruling on page 7, Judge Cannon says no party has offered any authority that would preclude a district court, in other words, her, the judge, that would preclude me from exercising my discretion to permit a charged defendant from factually testing a government's proffer on the applicability of the crime fraud exception, much less any authority impinging on my reasonable discretion to permit development of a record on contested questions of fact, as is the case here on the second prong of the crime fraud inquiry. So friends, can I translate that from legalese into English? Because what Judge Cannon is actually saying there to Jack Smith is, you couldn't find a case saying, I can't do this. She's not saying that there is some law, some precedent saying that this hearing is necessary. She's saying, you can't stop me. But actually, Jack Smith can stop her from continuing to show favoritism toward Donald Trump, or at least he can try to stop her by filing a motion that asserts that her impartiality might reasonably be questioned, such that she should be removed and replaced with a fair, independent, impartial judge. Because justice matters. Friends, try not to be discouraged, because we will never stop fighting for justice. And as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.